Actually, I'm asked to speak on the Chinese mainland system, the data protection, data privacy law in the mainland. I prepared a very academic presentation, but due to the limit of time, 15 minutes, I must go quickly. Introducing you the key component of the Chinese law, and also those key aspects that I think we should pay attention to, particularly for those working in companies and or lawyers advising companies. And my speaker will focus on these several topics very quickly. And the first one, I would say that in China, there's no a single comprehensive data protection law, but we have a set of major laws governing data protection, including personal data and also other data. There are three pillars of the system of law. As Ada as well mentioned, that the first one is the CSL, cybersecurity law. As the first law focusing on the network operation. And it's emphasized on the network information security. The second one is data security law, the DSL, and it introduced the system of classification of data by importance, emphasizing the security and the openness of government data. The third one, the core one of the system of law, is the PIPO, Personal Information Protection Law. It's relatively recent, however, it's very important in relation to personal data. Here, I emphasize personal data, not all the data. This law providing principles and rules governing the processing of personal data. It highlights personal rights. It also clarifies the obligations, duties of the government and also personal data processors. Indeed, China started this lawmaking process as early as 2023, and it went on by publishing different regulations and rules and normative documents. In the end, you see there are two major, I would say, cornerstone laws. The first one is civil code. Civil code is not a part of this, what I call three pillars. However, it laid down the fundamental principles governing the protection of personal information and set up tort liabilities for breaches. And of course, we know the PIPO, which is ongoing and effective. These three laws have internal connections in relation to the scope of the range and the security review, as well as liabilities. You see, the first one, cybersecurity law, the primary purpose of this law is to regulate activities of network operations. And in this law, it introduced a multi-level protection scheme, and according to which network operators should perform the security protection duties according to the requirement of cybersecurity multi-level protection system to ensure the network is free from interference, damage, and unauthorized access, and to prevent the network data leaks, theft, and falsifications, etc. The second one, this data security law, covers not only personal data, but also other data. The law introduces data classification and the grading system. According to classification, and data can be ordinary data, important data, or core data. Or according to the grading system, you see the 4 levels of data. the PIPO. This law applies to identified and identifiable personal information of natural persons. That is a Chinese legal term. Natural person, that means you, him, and me, natural persons. And the personal information includes all kinds of information recorded by electronic or other means related to identified or identifiable natural persons. And it has a wide range of application. It governs activities inside China as well as outside China, which means this law has an extraterritorial effect. And my second topic is 3+N framework. And actually, N includes many other things. According to the Chinese legal system, laws are made by NPC or NPCC, and the regulations can be made by State Council, State Council's department, and other authorities exercising public functions. And there are many others we call the normative documents. So as lawyers, you know, China's normative documents are much more numerous than laws and the regulations. So this system is well established and has a wide coverage and needs further detailed guidance to meet challenge in the enforcement process. It has strengthened, intensified intensity of supervision you'll see from the three laws, the supervision by the government, personal information protection law. Here, let's have a quick look at this law. This law is pretty much open-minded. It is modeled on the European GDPR. It includes, for example, these 6 legal principles governing the processing of personal information, like legality, purpose limitation, minimum necessity, openness and transparency, integrity, accountability. I would say that these principles are not invented or created by Chinese authorities. It borrows from overseas experience, for example, GDPR. Here, if you compare GDPR with the Chinese PIPO, you find a similarity. That's no surprise. And I would say this is good sense. It's good sense. And the law spent a lot of ink on the rules governing the processing of personal information. And the core the core rule of the data processing is notice or consent. We call it right to consent principle. And look at Article 13. The personal information processors may only handle personal information where they conform to one of the following circumstances. This obtaining individual's consent. That is the primary one, the first and primary one, which means without consent, processing is not possible. However, look at paragraph 2 to 7. Obtaining individual consent is not required under conditions in item 2 to 7, which means apart from, and in addition to the general principle, we see quite a number of exceptions. So those exceptions open doors to the other activities and to government as well. Let's compare GDPR and the PIPO. And the requirement of consent is mandatory in GDPR. However, there are flaws in the Chinese PIPO. For example, there's less specification leads to fail to guarantee free to give For example, if you use WeChat, the WeChat system often, I'm not saying mislead you, there are kind of flaws in terms of the use of personal data, personal information. And it does not comply with GDPR's high standard of informed. And there are cases in China that that concerns these regulations. And in this law, I would say, the sensitive personal information protection heightened. And the law especially separates general information from sensitive personal information. Article 28 describes what those sensitive information is. And of course, the consent is imposed as far as the processing of sensitive information. And in the law, the specific regulation on the state organs heightened. The state organ have the power to process personal information, as well as other information processors. So the law imposes duties on the state organs to protect as much as possible the individual's rights. And I would say this law is more or less a rights-based legislation. You see here, the law stipulates the following rights: right of know, the right to decide, the right of access to replication, right of portability, etc., etc. They are very comparable to European Union's GDPR. Compared with the GDPR, the Chinese law has flaws as well, and no time to explain. And we have further concerns out of this law. For example, we have cases actually. The first case is the DD case. In this case, the Cybersecurity Review Office conducted a cybersecurity review towards DD company. DD company is famous for, it's very useful and convenient company, according to the current law. Upon further investigation, it was found that DD violated cybersecurity law, data security law, and the PIPO. The second case is AI face changing software. The act of making a face change is not a legal infringement of portrait right. However, unauthorized use of other people's identifiable appearance constitute violation of right interest of personal information. And what I need to pay attention here in Hong Kong is about transferring personal information out of Mainland. And there are a legal framework governing transferring the personal data out of the Mainland. You see, at the national level, you have a set of laws, including laws, regulations, normative document. And at the local level as well, local government or interregional government publish as well those regulations and guidelines concerning transfer. The system creates three basic systems, which are security assessment, certification, standard contract. Now, I think many of you as lawyers, you may be very aware of standard contract. That's widely used according to Chinese law and in the Chinese law. There are relevant cases published, judicial cases published, and would provide good reference for us. And lastly, we have to face emerging technology data privacy challenges. The first one is public surveillance. What can we understand in China? The law imposes very strict surveillance oversight mechanism there, because the law would like to balance individual rights and security, national security, and the public interest. The second challenge is AI related, because we know, and Ada has already explored on that. There are more emerging issues such as unsecured data storage and doxxing. Doxxing is not only a Hong Kong issue, and mainland as well. And algorithmic transparency, no clear paper guideline on that. And the less regulated personal information profiling. This is what they call in Chinese 杀手, you know that, killing this frequent user. If you use C-Trip or Trips or those apps, you know this very well. There are more. And this is a brief introduction to the Chinese case. Thank you very much.